Listings and agency. The listing brokerage agreement. A listing is a personal service employment contract between the broker and the real property owner who wants to sell or lease their property. In this limited agency agreement, the owner promises to compensate the broker for finding a buyer or a tenant to purchase or lease the property. Any party who has ownership interest in a property must be identified and should sign the listing to validate the contract. That is so important. Unless there's a power of attorney for some other owner on a deed, then that other owner also needs to sign the listing contract, the listing agreement. If there's a husband and wife, unless the husband or whoever's present has power of attorney for the other party, both parties have to be present to sign the listing agreement. Licensee should request a copy of the property owner's deed to verify the names of all parties that need to sign the listing agreement. If owners are unable to provide document of title, a copy of the deed may be found in the county court records under the grantor or grantee index. I believe it is in good practice for you to, if you're going on a listing presentation, pull the deed first. Look at the tax records first to see who needs to sign. I had a situation where I went to a listing appointment and I pulled everything before I went. And I got there and it was the Mrs., an older lady, she was the Mrs., and her kids were making her move out of the home. Her name was not on the deed. It was not on the tax record. So while I'm speaking to her, I asked, who is Mr. blank, blank, blank? She said, oh, that's my husband. He's deceased. So you follow a chain of questions there. Okay, so he's deceased. I said, do you have any kids? Nope, it was just me and my husband. Does he have a will? Yes. And he left everything to me in the will. Do you have a copy of it? Yes. So that helps to clear up any background of who can actually sign this listing agreement. The person whose name on it left it to his wife in a will. Enough said. Okay? And there were no heirs. Enough said. A broker earns the promised compensation commission when a contract offer from a ready, willing, and able buyer or tenant to purchase or lease the property is presented to the seller at price and terms indicated as acceptable to the owner in the listing agreement. The commission is typically received by the broker at the closing of the transaction. That's very important. Ready, willing, and able buyer. Once you've listed a property, you brought a ready, willing, and able buyer to that property owner, and that property owner accepts that deal and everything goes through, your commission is received at the closing. A listing agreement does not require the owner to sell or lease the property, and absent a power of attorney, does not authorize the licensee to directly enter into a contract on the seller's behalf. It does, however, obligate the client to pay the broker when the broker has earned that compensation for performing the services slated in the listing agreement. So if I have brought that ready, willing, and able buyer to that listing, I've earned my commission. That's what I was hired to do. If not, the compensation duly earned for the services provided, which was to bring a ready, willing, and able buyer, and so stated in the listing agreement, the broker may take legal action against the client. To be entitled to receive compensation from a real estate transaction, the broker must be actively licensed as a real estate broker, be employed by the client under a valid brokerage agreement, show they were procuring cause of the sale, which means they brought the ready, willing, and able buyer. Okay, and that's how they would earn the commission. Exclusive right to sell listing agreement, most commonly offered by brokers in Georgia, appoints brokers as the exclusive agent of the property owner who agrees to compensate broker no matter the circumstances under which a buyer or tenant for the property is produced. Such circumstances include if a buyer is found by the seller's listing broker, if the buyer found by cooperating broker with whom the listing broker may share commission earned from the seller, if buyer found by seller without broker assistance. So all of these would be reasons. This would be the procuring cause that the property, the agreement is being satisfied between the seller and the agent for the seller. Cooperating broker is the brokers that bring buyers to view the property. Okay, they're cooperating with the listing agent. They've seen the property on the multiple listing service. The property fit a few requirements for one of their existing buyers. Their existing buyers came by, checked out the house, liked what they saw, put an offer in, and the rest was closing history. Then the listing agent owns their commission. Even if the seller found someone, what if someone saw the sign in the yard and said, oh, I really like that house. Let me go and knock at the door, ring the bell to see if I can see it. And the seller lets them in and allows them to look at the property. The agent still earns a commission because they found a ready, willing, and able buyer to buy the house. Even though the agent was not present. The agent sign is present outside. That draws people in. Okay? But the agent wasn't present. Buyer knocked at the door. Seller let him in. No assistance from the agent. Agent still earns the commission. Okay? Exclusive listing must be in writing and must include specific termination dates. There has to be a beginning and end date on the listing agreement. Affiliated licensee working as agent for the exclusive broker owes the same duties and obligations to the seller as does the broker. As a result, the affiliated licensee has a dual responsibility, both to the broker and to the broker's client, because remember, all deals belong to the broker, right? So as an affiliated licensee under my broker, okay, I still owe and have a dual responsibility to both the broker and the client. Thus, a listing contract typically involves two agency relationships, one between the broker and sales affiliate, and the other and the seller, as well as one between the broker and his or her sales affiliate. Okay, so there's two agency agreements because I, as a listing agent, I have it's my broker. I'm working with my broker, okay? So that's agency, okay? And then I'm also working with the seller. That's agency as well. Multiple listing service clause. Commonly included in exclusive right to sell listings used by brokers members of the MLS. Under the provisions of this clause, the seller authorizes the broker to cooperate with other brokers who are showing the property to prospective buyers, as well as offering to share with those brokers the commission paid to the listing broker by the seller. So a moment ago, I mentioned cooperating brokers. That's the brokers who see my listing in the multiple listing service. When I sign my agreement with the seller, I've already put in writing to the seller that I am sharing my commission with a cooperating broker that brings prospective buyers to the property. And that's what this is. Broker Protection Safety Clause. Exclusive listing agreements in Georgia commonly include this clause, which provides that a property owner will pay the listing broker a commission within a specified number of days after the listing has ended if that buyer had been exposed to the property during the terms of the broker's listing contract with the seller. Okay, this is a protection clause. Okay, and it protects the broker's commission. So if the listing has expired and a buyer who previously saw the property while it was listed, okay, during the listing terms, ends up buying the property, then I'm still owed a commission as the broker. Open listings. A non-exclusive agency contract in which the owner of a property can retain one or more brokers and one in which the owner retains the right to sell or lease the property without having to compensate the broker. I'll read that again. A non-exclusive agency contract in which the owner of a property can retain one or more brokers and one in which the owner retains the right to sell or lease the property without having to compensate the broker. So what that means is if it's open, anybody who brings a ready, willing, and able buyer gets the commission. And that's that. Any broker that brings a ready, willing, and able buyer gets the commission. Any one of those brokers that was retained by the owner. If he retained 6, I just want the house sold. I don't care how many of you it is. Okay, whichever one brings me a buyer gets the money. That's what open listing is. The only broker here to receive a commission is a broker who procures a ready, willing, and able buyer on the terms acceptable to the seller. Procuring costs in a real estate transaction refers to a party whose efforts bring about the desired transactional results as set forth in a listing contract. And what are the desired transactional results? Bringing that ready, willing, and able buyer. While there is no requirement that an open listing be in writing in Georgia, without written permission from the seller, a broker cannot place a sign on the property offered for sale. Moreover, a verbal open listing contract may not be enforceable in a court if seller and brokers are disputing which property procured the sale. So there's some risk involved with an open listing, especially when it's not in writing. Net listing, brokerage contract in which the owner of the property sets a specific dollar amount for which they will sell the property, and the broker commission amount will consist of the dollar amount over the seller's stated figure. Net listings are prohibited in Georgia because of the potential conflicts they can create between interests of the seller client and the broker self-interest. And can you see why that's a problem? If the seller says, you know what, I want $300,000. That's what I want to walk away with net. Everything else is yours. Can you see why there would be a problem? If it's sold for $400,000, $100,000 goes to the agent or to the broker. Of course, the broker should try to get the highest and best amount. But what if the highest and best amount is $100,000 more? And the seller, I just want $300,000. Everything else can go to you. That can create a problem. Conflicts of interest, actually. Comparative market analysis prior to initiating a listing contract with the broker, or more commonly, the licensee affiliate representing the broker. The property owner will commonly expect the agent's advice on selling price for the property. To arrive at an owner's desired net proceeds from the transaction, so we do a comparative net market analysis to assess the value of property in the area. Usually it's within a mile or 2 miles. It depends on the comps, the comparables to the property that's going to be listed.